Good day, sir. And this is my reading activity in Article 14 and 15. First is the Article 14 or aggravating circumstances that advantage be taken by the offender of his public position. And this is the aggravating circumstances requisite. So first, the offender is a public officer. Second is the commission of the crime would not have been possible without the powers, resources, and influence of the office he holds. Essential or public officer use the influence, prestige, or ascendancy which his office gives him as the means by which he realizes his purpose. Failure in official is tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his position. Second is that the crime be committed in contempt or of or with insult to the public authorities. And the requisite is the offender knows that a public authority is present, the public authority is engaged in the exercise of his functions, the public authority is not the victim of the crime. Fourth is the public authority presence did not prevent the criminal act. Example is Juan and Pedro are quarreling and the municipal mayor, upon passing by, attempts to stop them. Notwithstanding the intervention and the presence of the mayor, Juan and Pedro continue to quarrel until Juan succeeds in killing Pedro. Person in authority, public authority, who is directly vested with jurisdiction, has the power to govern and execute the laws. Examples of person in authority is first the governor, second the mayor, third the barangay captain, fourth is the councilors, fifth is the government agents, and sixth is the chief of police. So role not applicable when committed in the presence of mere agent. Agent is the subordinate public officer charged with the maintenance of public order and the protection and secure of life and property. Example is the barrio vice lieutenant, barrio councilman. So third, that the act be committed first with insult or in disregard of the respect due to the offended party on account of his A. rank, B. age, C. S6, or that it be committed in the dwelling of the offended party. If the latter has not given provocation, circumstances is the rank, age, and sex may be taken into account only in crimes against person or honor. It cannot be invoked in crimes against property. Rank or refers to a high social position or standing by which to determine one's pay and in emoluments in any scale of comparison with a position. Age, the circumstances of lack of respect due to age applies in case where the victim is of tender age as well as of old age. So, six, sex is refers to the female sex, not to the male sex, not applicable when the offender acted with passion and obfuscation. There exists a relation between the offender and the victim, but in cases of divorce decrees where there is a direct bearing on their child, it is applicable. The condition of being a woman is indispensable in the commission of the crime. Example is the parricide, rape, or abduction. Requisite of disregard to rank, age, or sex. First is the crime must be against the victim's person or his honor. There is deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. Disregard to rank, age, or sex is absorbed by treachery or abuse the strength. Dwelling, it must be a building or structure exclusively used to rest and comfort, combination house and store not included. So number one may be temporary as in the case of guests in a house or bed spacer. Number two is basis for this is the sanctity of privacy the law accords to human abode. Dwelling includes dependencies, the foot of the staircase and the enclosure under the house. Elements of the aggravating circumstances of dwelling. First is the crime occurred in the dwelling of the victim. Second is no provocation on the part of the victim. So requisites for provocation all must concur. Number one is given by the owner of the dwelling. Second is the sufficient. Third is the immediate to the commission of the crime. When dwelling may add may not be considered. So when it may be considered, it is although the offender fired the shot from outside the house, as long as his victim was inside. Even if the killing took place outside the dwelling so long as the commission began inside the dwelling. When adultery is committed in the dwelling of the husband, even if it is also the dwelling of the wife, it is also aggravating because she and her paramour committed a grave offense to the head of the house. In robbery with violence against persons, robbery with homicide, abduction, or illegal detention. If the offended party has given provocation, so when it may not be considered. So the victim is outside his or her dwelling. And if offended party are not occupants of the said dwelling. So, in when it may be considered if both the offender and the offended party are occupants of the same dwelling, and robbery with force upon things it is inherent. So number four, what the act be committed with one abuse of confidence or two abuse ungratefulness. So requisite of abuse confidence, A is the offended party has trusted the offender. B. Offender abused such trust. C. Abuse of confidence facilitated the commission of the crime. So requisite of abuse ungratefulness. A is ungratefulness must be abused. That is, there must be something which the offender should owe the victim a debt of gratitude for. So note, robbery or theft committed by a visitor in the house of the offended party is aggravated by obvious ungratefulness. So example, a jealous lover already determined to kill his sweetheart, invited her for a ride and during that ride, he stabbed her. So abuse of confidence is inherent in first is the malversation, second is the qualified thief, third is the estafa by conversion, fourth is the misappropriation, fifth is the qualified seduction. So number five, that the crime be committed in the palace of the chief executive or in his presence, or when public authorities are engaged in the discharge of their duties or in a place dedicated to religious worship. So, requirements of the aggravating circumstances of public office. A polling precinct is a public office during election day. Nature of public office should be taken into account, like a police station which is on duty 24 hours a day. So, place of the commission of the felony. Part 5, it is the Malacanang Palace or a church is aggravating regardless of whether state or official. Functions are being held. So as regard other places where public authorities are engaged in the discharge of their duties, there must be some performance of public functions. The offender must have intention to commit a crime when he entered the place. So requisites of aggravating circumstances for place of worship. So first is the crime occurred in the public office. Second is the public authorities are actually performing their public duties. First is the crime occurred in a place dedicated to the worship of God regardless of religion. Second is the offender must have decided to commit the crime when he entered the place of worship. So, when paragraph 2 and 5 of Article 14 are applicable, so committed in the presence of the chief executive in the presidential palace or a place of worship is the paragraph 5, Article 14. So, public authorities are performing of their duties when the crime is committed. So, when crime is committed in the public office, the office must be performing his duties except in the presidential palace. So, public authority may be offended party. So, when it may be not be consider. So, committed in contempt of public authority is the paragraph 2 in Article 14, and it is the same outside the office still performing duty. Public authority is not the offended party. So, in number 6A, that the crime be committed one in the night time or two in an uninhabited place. 3. By a band, whenever such circumstances may facilitate the commission of the offense. Nighttime or uninhabited place or by a bang aggravating when. So impunity means to prevent the accused being recognized or to secure himself against detection or punishment. Nighttime begins at the end of dusk and ending at dawn, from sunset to sunrise. An inhabited place is the one where there are no houses at all. A place at a considerable distance from town where the houses are scattered at a great distance from each other. First, it is facilitated the commission of the crime. Second, is especially sought for by the offender to ensure the commission of the crime or for the purpose of impunity. When the offender took the advantage thereof for the purpose of impunity. Four is the commission of the crime must have been begun and accomplished of that time. So number one, the commission of the crime must begin and be accomplished in the night time when the place of the crime is illuminated by light. Nighttime is not aggravating or absorbed by treachery. So the requisites, the place facilitate the commission or omission of the crime. Two, deliberately sought and not incidental to the commission or omission of the crime. 3. Taken advantage and 4. And off for the purpose of impunity. What should be considered his is whether in the place of the commission of the offense there was a reasonable possibility of the victim receiving some help. So 6B, whenever more than three armed malefactors shall have acted together in the commission of an offense, each shall be deemed to have been committed by a band. So, a requisite, if one of the four armed malefactors is principal by inducement, they do not form a band because it is undoubtedly connoted that he had no direct participation. Band is inherent in robbery committed in band and brigandage. It is not considered in the crime of rape. It has been applied in treason and in robbery with homicide. Number one is the facilitated the commission of the crime. Number two, deliberately sold. Number three, taken advantage of for the purposes of impunity. Four, there must be four or more armed men. So number seven, that the crime be committed in the occasion of a conflagration, shipwreck or earthquake, epidemic or other calamity or a calamity or misfortune. So committed with the use of wasteful means. So crime is committed during any of the calamities. So crime is committed by using fire or inundation, explosion, or other wasteful means. So now paragraph 8, that the crime be committed with the aid of one armed man or two persons who ensure or afford impunity. cooperated with him in the commission of the crime acted under the same plan and for the same purpose. Number three is the casual presence, or when the offender did not avail himself of any of their aid or nor did not knowingly count upon their assistance in the commission of the crime. So, with the aid of armed men, present even if one of the offenders merely relied on their aid or actual aid is not necessary. So, in a by a band requires more than three armed male factors who all acted together in the commission of an offense. So, if there are more than three armed men, aid of armed men is absorbed in the employment of a band. So, that the accused is a recidivist. So, nine, the accused is a recidivist. So, recidivist, one who at the time of his trial for one crime shall have been previously convicted by final judgment of other crime implies in the same title of the PRC or no, the RPC. So the basis is greater perversity of the offender as shown by his inclination to commit crimes. So the requisite is first the offender is on trial for an offense. Two, he was previously convicted by final judgments of another crime. Three, that the both the first and the second offenses are embraced in the same title of the RPC. So fourth, the offender is convicted of the new offense. So when we say recidivism, it must be taken into account no matter how many years have intervened between the first and the second felonies. Pardon does not obliterate the fact that the accused was a recidivist, but amnesty extinguishes the penalty and its effects. To prove recidivism, it must be allied in information and with attached certified copies of the sentence rendered against the accused. Exceptions: if the accused does not object and when he admits in his confession and on the witness stand. So paragraph 10, that the offender has been previously punished or an offense to which the law attaches an equal or greater penalty, or for two or more crimes to which it attaches a lighter penalty. So, reiteration or habituality, it is essential that the offender be previously punished, that is, he has served sentence. Paragraph 10 speaks of penalty that attached to the offense, not the penalty actually imposed. So, reiteration, it is the necessary that the offender shall have served out his sentence for the first sentence. So previous and subsequent offense must not be embraced in the same title in the code. Not always an aggravating circumstances. So in recidivism, so enough that final judgment has been rendered in the first offense and also same title and always aggravating. So habitual delinquency. When a person within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robbery or thief, estafa or falsification is found guilty of any of said crimes a third time or oftener. So, quasi-recidivism. When we say quasi-recidivism, it is that any person who shall commit a felony after having been convicted by final judgment. So, before beginning to serve such sentence or while serving the same, shall be punished by the maximum period of the penalty prescribed by law or the new felony. So, number four is the forms of repetition. First is we have four forms of repetition. First is the recidivism or the generic. Second is the reiteration or habitually, and it is also generic. Number three, multiple recidivism, the recidivism or habitual delinquency. It is the extraordinary aggravating. When we say quasi-recidivism, it is the special aggravating. So, paragraph 11, that a crime be committed in consideration of a price, reward, or promise. So the requisite is at least two principles: the principle by inducement, the principle by direct participation, or the price, reward, or promise should be previous to and consideration of the commission of the criminal act. So applicable to both principles. So in paragraph 12, that a crime be committed by means of inundation, fire or poison, explosion or stranding a vessel or international damage thereto or the derailment of a locomotive or by use of any other artifice involving great waste or ruin. So the requisite, the wasteful means were used by the offender to accomplish a criminal purpose. 13. That the act be committed with evident premeditation. So, essence of premeditation, the execution of the criminal act must be preceded by cold thought and reflection upon the resolution to carry out the criminal intent during the space of time sufficient to arrive at a calm judgment. So, the requisite is the time when the offender determined to commit the crime. Second is that an act manifestly indicating that the culprit has clung to his determination. Third, a sufficient lapse of time between the determination and execution to allow him to reflect upon the consequence of his act and to allow his conscience to overcome the resolution of his will. So conspiracy generally presupposes premeditation. When victim is different from that intended, premeditation is not aggravating. Although it is not necessary that there is a plan to kill a particular person for premeditation to exist in example plan to kill first two person one meets general attack on a village for as long as it was planned. So the premeditation must be based upon external facts and must be evident, not merely suspected, indicating deliberately planning. So evident premeditation is inherent in robbery, adultery, thief, estafa, or falsification, and etc. So in paragraph 14, that one craft, two fraud, or three disguise be employed. First is the craft. It is involves intellectual trickery and cunning on the part of the accused. It is employed as scam in the execution of the crime. Example is the accused pretended to be members of the constabulary, accused in order to perpetrate rape, use chocolates containing drugs. So, fraud, when we say fraud, it is involves insidious words or machinations used to induce victim to act in a manner which would enable the offender to carry out his design. So as distinguished from crop which involves acts done in order not to arouse the suspicion of the victim. So fraud involves the direct inducement through entrapping or beguiling language or machinations. So these guys resorting to any device to conceal identity, purpose of concealing identity is a must. So distinction between craft, fraud, and disguise. When we say craft, it is involves the use of intellectual trickery and cunning to arouse suspicion of the victim. And the fraud, it is involves the use of direct inducement by insidious words or machination. And the disguise, it is involves the use of device to conceal identity. So the requisite is the offender must have actually take advantage of craft, fraud, or disguise to facilitate the commission of the crime. Inherent in is the estafa and falsification. So, paragraph 15, that one advantage be taken of superior strength, or two means by employed to weaken the defense to purposely use excessive force out of the proportion to the means of defense available to the person attacked. So requisite of means to weaken defense is means were purposely so to weaken the defense of the victim to resist the assault. Second is the means used must not totally eliminate possible defense of the victim, otherwise it will fall under treachery. To weaken the defense, illustrated in the case where one struggling with another suddenly throws a clock over the head of his opponent, and while in the said situation, he wounds or kills him. Other means of weakening is the defense would be intoxication or disabling through the senses or casting dirt of sand upon another eyes. Number one is the superiority may arise from aggressor sex, weapon or number or as compared to that of the victim accused attack an unarmed girl with a knife. Three men stabbed to death the female victim. No advantage of superior strength when one who attacks and overcome with passion and obfuscation or when quarrel arose unexpectedly and the fatal blow was struck while victim and accused were struggling. So, versus by a ban, so circumstance of abuse of superior strength, what is taken into account is not the number of aggression, nor the fact that they are armed but their relative physical might vis as vis the offended party. So in paragraph 16, that the act be committed with treachery or the alivotia. Treachery when the offender commits any of the crime against the person. Employing means method of forms in the execution thereof which tend directly and especially to ensure its execution without risk to himself arising from the defense which the offended party might make. So the requisite it is that at the time of the attack, the victim was not in the position to defend himself. And two, that the offender consciously adopted a particular means, method, or form of attack employed by him. So treachery can't be considered when there is no evidence that the accused prior to the moment of the killing. So resolved to commit the crime, or there is no proof that the death of the victim was the result of meditation and calculation or reflection. So examples is the victim asleep, half awake or just awakened, victim grappling or being held stuck from behind. But treachery may exist even if attack is face to face, as long as victim was not given any chance to prepare defense. So one does not exist if the accused gave the deceased chance to prepare or there was warning given or that it was preceded by a heated argument. Two, there is always treachery in the killing of child. Three is generally characterized by the deliberate and sudden and unexpected attack of the victim from behind without any warning and without giving the victim an opportunity to defend himself. So, treachery means method or forms are employed by the offender to make it impossible or hard for the offended party to put any sort of resistance. And the abuse of superior strength, offender does not employ means methods or forms of attack. He only takes advantage of his superior or strength. Means employed to weaken defense. Means are employed but it only materially weakens the resisting power of the offended party. Where there is conspiracy, treachery is considered against all the offenders. Treachery, absorb abuse of strength, aid of armed men by a band and means to weaken the defense. Paragraph 17 say that the means be employed or circumstances brought about which add ignominy to the natural effects of the acts. When we say ignominy, it is a circumstances pertaining to the moral order which add disgrace and oblugi to the material injury caused by the crime. So applicable to crimes against chastity, rape included, less serious physical injuries, light or grave coercion, and murder. So the requisite is the crime must be against chastity, less serious physical injuries, light or grave coercion, and murder. The circumstance made the crime more humiliating, shameful for the victim. So examples, accused embrace and kiss the offended party not out of lust but out of anger in front of many people. Rape in front of the husband, rape successively by 5 men. tend to make the effects of the crime more humiliating. So, ignominy not present where the victim was already dead when such acts were committed against his body or person. So, in paragraph 18, that the crime be committed after an unlawful entry. So, unlawful entry, it is when an entrance is effected by a way not intended for the purpose, meant to effect entrance not exist. So, why aggravating? So, one who acts not respecting the walls erected by men to guard their property and provide for the personal safety shows greater perversity, a greater audacity, and hence the law punishes him with more severity. Example is the rapist gains entrance through the window. Inherent in trespass to dwelling, robbery with force upon things, and robbery with violence or intimidation against person. So in paragraph 19, that as means as to the commission of the crime, a wall, roof, door, or window be broken. Requisite is a wall, roof, window, or door was broken. They were broken to effect entrance. Applicable only if such acts were done by the offender to effect entrance. An officer, in order to make an arrest, may break open a door or window of any building in which the person to be arrested is or is reasonable believed to be. An officer, it refused admittance, may break up open any door or window to execute the search warrant or liberate himself. So in paragraph 20, that the crime be committed one with the aid of persons under 15 years of age, or two by means of motor vehicles, airship, or other similar means. So reason for number one, to repress, so far as possible, the frequent practice resorted to be professional criminals, to avail themselves of minors taking advantage of their responsibility. Remember that minors are given leniency when they commit a crime. Example, Juan introduced a 14-year-old to climb up the fence and open the gate for him so that he may rob the house. So reason number two, to counteract the great facilities found by modern criminals, instead means to commit crime and flee and abscond once the same is committed. Necessary that the motor vehicle be an important tool to consummation of the crime. So bicycles is not included. So example, Juan and Pedro in committing thief use a truck to haul the appliance from the mansion. So in paragraph 21, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. So cruelty. When culprit enjoys and delights in making his victim suffer slowly and gradually, causing him unnecessary physical pain in the consummation of the criminal act. Cruelty cannot be presumed or nor merely inferred from the body of the deceased has to be proven. So mere plurality of words do not show cruelty. No cruelty when the other wrong was done after the victim was dead. So the requisite that the injury caused by deliberately increased by causing other wrong, that the other wrong be unnecessary for the execution for the purpose of the offender. So ignominy or moral suffering subjected to humiliation. So the cruelty is the physical suffering. So let's go to the in Article 15. So Article 15 is the alternative circumstances. So alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and the other conditions. Attending its commission, they are the relationship, intoxication, and the degree of instruction and education to the offender. So the alternative circumstances of relation shall be taken into consideration when the offended party in the spouse, ascendant, descendants, or descendant or legitimate, natural or adopted brother or sister, or relative by affinity in the same degrees of the offender. So the intoxication of the offender shall be taken into consideration as mitigating circumstances when the offender has committed a felony in a state of intoxication if the same is not habitual or subsequent to the plan to commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstances. So alternative circumstances, those which must be taken into consideration as aggravating or mitigating according to the nature and effects of the crime and other condition attending its commission. So they are relationship. So taken into consideration when offended party is the spouse or ascendant or descendant or legitimate, natural or adopted brother or sister or relative by affinity in the same degree of the offender. So, intoxication, mitigating when the offender has committed a felony in the state of intoxication, if the same is not habitual or subsequent to the plan to commit the said felony, aggravating if habitual or intentional. So, degree of instruction and education of the offender. So, relationship, mitigating circumstances in crimes against property, robbery, usurpation, fraudulent, insolvency, or arson. So, in aggravating circumstances in crimes against person, in case where the offender or when the offender and the offended party are relatives of the same level, as killing a brother, adopted brother, or half brother. So always aggravating in crimes against chastity. So exception, Article 332 or 332 of CCC, no criminal liability or civil liability only for the crimes of thief, swindling, or malicious mischief committed or caused mutually by spouses, ascendants, descendants, or relatives by affinity. Also, brothers, sisters, brother-in-law, or sister-in-law, if living together, it becomes unaccepting circumstances. So, relationship neither mitigating nor aggravating when relationship is an element of the offense. So, example is the parricide, adultery, and concubinage. So, intoxication, mitigating circumstance, uh, first is that if intoxication is not habitual, and in aggravating circumstances, if intoxication is habitual, such habit must be actual and confirmed. So, in mitigating circumstances, B, if intoxication is not subsequent to the plan to commit a felony, so the aggravating circumstances is it is intentional subsequent to the plan to commit a felony. So must show that he has taken such quantity so as to blur his reason and deprive him of a certain degree of control. So a habitual drunkard is given to in inebriety or the excessive use of intoxication drinks. So habitual drunkenness must be shown to be an actual and confirmed habit of the offender, but not necessarily of daily occurrence. So degree of instruction and education. So mitigating circumstances, low degree of instruction, education, or the lack of it because he does not fully realize that the consequence of his criminal act not just mere illiteracy but lack of intelligence. So aggravating circumstances is the high degree of instruction and education offender avails himself of his learning in committing the offense. So determined by the court must consider the circumstance of lack of instruction and exceptions not mitigating. So crimes against property or crimes against chastity or rape included and crime of treason. So take note of the abbreviation of GAMAA in Article 11 to 14. So, the the significance or the important details in aggravating circumstances is that aggravating circumstances is that worsen the severity of the offense and increase the punishment. So the increased punishment, it is such as longer prison sentence or higher fines. So, in maximum penalty, it is allowed by law for a particular offense. So, in intentional harm, it is the actions that demonstrate a higher level of culpability or malicious intent. So, in victim impact, physical harm, emotional trauma, or financial loss and abuse of power. So abuse their possession and authority or trust to commit offense. So that is in aggravating circumstances. And the number six, it is the repeat offenses indicating a disregard for the law. And seven is the planning and premeditation may include evidence or careful planning or premeditation. And number eight is the vulnerable victims committed against vulnerable individuals such as children and the elderly or disabled person. So that is the eight important details or significance of aggravating circumstances and also the alternative circumstances. So when we see alternative circumstances, it are those must be taken into consideration or aggravating or kanay mitigating circumstances according to the nature effects of aim. So thank you for listening my reading activity. Thank you.